Good evening. You are joining with Law and Order on ChannelEye. In this program, we extract and explore about certain laws and regulations that are governing the country, Sri Lanka, because that's important for us as citizens to know about these laws. And for that, we have requested help. And for that request, we have received Mrs. Nurani Amarasinghe, attorney at law, Notary Public, with 28 years of experience, who's specializing in property law and among many other legal aspects at the same time. So today's program being about rent and leasing aspects of when it comes to law. We're going to start off with this first question because we all want to know exactly the difference between these two terms that we use, leasing and renting. Good evening to you.
Good evening.
So what's the difference, as I mentioned, the definition of that?
Well, when you say a rent agreement, it is for a short period of time. And rent agreements are not notarially executed. That means that there are two parties, it's a contract.
Right.
There are two parties, they are contracting, and it is signed only before two witnesses. There's no attestation made by a lawyer. Whereas a lease is concerned, a lease is for a longer period, and there will be a notary attesting it before two witnesses, and various conditions will be given. Unlike in the rent agreement, it is a monthly, it's a monthly contract. Here it is for a longer period.
And lease is longer.
Lease is longer.
Okay.
And it is notarially executed.
So you spoke about agreements. Now, it's not really that much of a common practice among some Sri Lankans to really write agreement, especially when you rent out your own apartment or something. You just verbally tell, fine, you come and stay, just give me the key money, and that's it. Is that enough? Is that safe?
As long as they honor the word, enough. But it doesn't happen. It never happens, actually.
Right.
So it is always better to have your agreement in writing. You specify all the conditions, what you expect that person to do. The rent, the time period, what is expected from him, how to look after the property, and when to leave, and in case he has to leave within before the contract is over, then what are the procedures you have to follow, whether you should give a notice, then how long before the contract is over or before you leave that you have to give. Sometimes you say 3 months, 1 month notice, then you have to comply with those conditions and give notice. Otherwise, what will happen is then all of a sudden a person will say, no, I want to go. Then the one party may have spent on the lawyer, entering into the agreement, and it is not fair by that party. So when you have to specify all the conditions that both parties are agreeing to abide by.
Right. So when it comes to the lease, the rent agreement, is there a way to customize it? Like, imagine you have a situation where you want to rent out just a small portion of your own house, maybe like a room. Can that be done?
Yes, that can be done.
That can be done.
That can be
that
done.
also gets included in
even
the
in
agreement.
a lease agreement, that can be done. Portion of your house, the annex, like that it can be done.
Right. So you mentioned about unfair eviction and also unfair the tenants leaving without notice. What kind of actions can the landlord take at such an instance?
It is like this. Now we'll assume that the agreement is valid for a year. The tenant wants to, or the lessee wants to leave after 6 months. Then if the agreement says 1 month's notice, he doesn't give 1 month's notice. But if the agreement covers up such a situation, like in lieu of that notice, you have to pay me for that month, then you are not at a loss. Right? You have to cover every situation. I don't say that each and every situation can be covered, but there are conditions, there are implied conditions. So you are expected to act bona fide. That means genuinely, with good faith. So if both parties act accordingly, then there won't be any issue. But the issue arises when some party violates the agreement.
Right. So this is fundamentally a violation to overstay or to sometimes not to
overstay
pay.
Is a violation, then that also must be provided. In case you are a overholding lessee, then these are the terms as a penalty.
Right.
So much of damages must be paid for per month.
Right. So what if the unfair at a situation where unfair eviction also happens? But
sometimes you might, I mean, the owner of the property, the lessor, may forcefully evict you.
Yes.
These things happen.
Yeah.
But that is not accepted. But if the agreement provides for such instances, then there won't be any problem. Even otherwise, you can go to courts and say, look here, this is the agreement, I have not violated. I have complied all the conditions whereas lessee is concerned. There had been unlawful eviction. Then you can litigate and claim your damages. But the problem is whether you are going to litigate for such things. I mean, because when you calculate the time of litigation, the money you have to spend, then there's a problem. So a lot of people give up. They bear their consequences. It is not a very healthy situation.
Okay. So just to iron out all these situations and to just avoid all of them, I think it's the best is to have a proper, very curated duration for your agreements. So what would be the ideal time? I mean, let's speak about different scenarios. Let's speak about renting a house, giving away a house on rent. We'll
assume it's a newly built house. So it is, you are giving in original condition. You must assume in the event the lessee damages this property, you must get a good security deposit first.
Okay, right. That's the procedure.
So that if there's any damage caused to the property, you are in a position to recover your damages.
Okay.
Sometimes they don't pay their bills. They keep everything in arrears and they vacate. Then the owner has to bear all the consequences. So these things are there. Sometimes the owner might try to evict the person, harass the lessee and then try to get him evicted. These things are there. But if the agreement provides, then you can fight for your right.
Okay. So these rights are both applicable to the once it's obtained in the house and so once you're given the house.
Yes, because the contract and agreement means it's not a one-sided agreement. It has to provide for both sides.
Both sides. Right. So I know this situation. I know this actual a live scenario that actually happened to someone I know who was on rent at a house, and he was forced to evict because because the landlord didn't want him to stay, and it was not even in the agreement that he can. I mean, you can't evict a person just like that. But then again, what the landlord did was they cut the electricity connection, and all the connections under all the utility connections were cut off, and they were forced to go. Is that legal? Can that be done?
No.
No.
Strictly no. You must go and fight for your right. If you have not violated the right, any condition, and if you have duly paid the rent, and if you have, like, it may say that you can't be disturbing the neighborhood, maybe there are various other conditions, but as long as you have not violated any of the conditions, you have a right to go to courts and say, look here, I have complied with all the conditions. For no reason, I am ousted. Right? You can get a restraining order or a mandatory injunction to get yourself in. Right?
Right. So as a tenant, then, like, usual way that we're used to give money is to just give by hand, by cash. But there's no way to prove it if it goes to that level. How do we prove that I gave the money? In that case, do you advise a bank transfer would be ideal? So that you can prove it?
Even if it is a cash payment, as long as there's a receipt for it.
Okay, receipt. Okay.
Signed before 2 witnesses, or even otherwise, where the money is concerned, that receipt is sufficient to show to prove the fact that you have paid this person this money.
Okay.
But apart from that, if it is a check or a bank draft, that is better evidence.
Better evidence.
That is impartial evidence.
Yes,
right?
Right. So it's always best to have something in written.
Something. Always you must have something in writing. Otherwise, problem.
Okay. Right. So when it comes to leasing of both immovable and movable property, we know that there are certain situations that happen in Sri Lanka. I mean, it gets sometimes your movable property gets seized by, you say, insurance or the financing company. Can that be done? Is that even legal to do that for?
It is legal. It's like this. I know a case where, in a divorce case, where the husband filed action, but ultimately the case was decided in favor of the wife, the defendant, and the defendant was, the husband was ordered to pay alimony to the wife.
Right. Okay.
Then the husband didn't pay, so the wife went and seized a property belonging to my client.
Right.
Right? So you can do it. But then I have to go and prove, look here, this property is not that plaintiff's, that her husband's property, this is my property. I have to show. Then you must forward your claim. You can go to courts and say, file an action claim. Those are called claims. You have to make a claim saying that these properties are belonging to me, not to this person. So that then the seizure will be removed. But if you are unable to prove, then the property can be seized.
Right. So at a point of this seizure, like when it comes to especially a vehicle, let's say a vehicle, and the insurance company comes and takes your vehicle somewhere in the, maybe on the road to your premise, somehow you sort of lose the ownership of it. Can that be recovered legally by at least by promising to pay the rest of it?
Well, you will be, the company will be seizing the immovable property only if the
payments
the lessee has violated the conditions of the agreement.
Right.
Then there's a procedure. The company must demand accelerated payments from the person who hired the vehicle.
That's the first step.
That's the first step.
Okay.
Right? If he doesn't pay, then the agreement says, and the law also says, that he shall return the vehicle to the company. Right? Only if it doesn't happen, only that the seizure takes place. When you have not paid, you are not entitled to enjoy the property. You have to hand over the property.
Okay. So it has to be something, this is why reading soft print is always important when it comes to agreeing to something, because all these are written very clearly on every agreement.
Written, and at the same time, whereas a company is concerned, when you go and try to repossess the vehicle, you must make that there's a procedure. You have to inform the police, there's a procedure to follow. You can't just go and seize it, because there can't be any breach of peace.
Yes.
So you have to inform the police, there's a procedure, and if you have to regain the possession from this company, you are entitled to go and show that I have complied, I have paid all the due payments, this has been done arbitrarily. You can go and prove, if you are in a position to prove those facts, you can get the vehicle back.
Right. So once again, that's why it is always very important to have everything in writing and documented with you so that you can prove it if you're innocent. Right. So moving on about these building rental dispute scenarios. Now, we know that sometimes people obviously, we discussed about that, but there are also situations where the tenant might want to improve or maybe build up or may add something, an element or some sort of a portion to the house that they are already occupying without the consent of the landlord. What is the relief?
If any improvements have been done without the consent of the landlord, you can't claim any compensation. But if there's an agreement between you and the landlord, then you have to enter into terms, even by a subsequent agreement. Otherwise, there must be some document to show that the monetary value, what the amount you spent on the improvements, will be paid or set off against the rent.
Right.
So those things also you have to negotiate and get in writing.
Right. Okay. So this compensation is given to you or is paid to you at the end of their term, or is it immediately?
That all depends on the agreement. Like some people come to terms, all right, in lieu of my rent, I will improve, I'll spend on this thing and get this part done. I'll build this portion and I'll continue to occupy, or I'll color wash, I'll do certain things. Then in lieu of my monthly rental, I will do these things. So if there's an agreement, there's no problem whatsoever. But it is always better to have whatever the agreement in writing.
Right. Okay, so when it comes to improving premises, once again, so if someone improves it without the permission of the landlord, what's the legal aspect?
If you are a monthly tenant, doing some improvements, structural changes is an offense. On that ground, you can have the tenant ejected. You are not supposed to do anything without written permission. If it is without any permission, there's no way.
Right.
So that
That's
you
how it
have
is.
to, I mean, those are called structural changes is recognized as an overt act, and then on that ground
Only.
you can eject that person.
Okay. On that ground, you can eject the person at the
Eject the
same time.
person.
Okay, but then for that, you have to seek
You have to
legal-
prove, you will have to get a commission. Commission means if you have filed action, you can appoint a surveyor or a valuer, some person, an engineer, to go and inspect and see what are the improvements that have been done, what are the changes that have been done to the original building. So with the report from an independent expert, they are called expert evidence, and you can, basing on that report, you can
Right.
succeed in an action.
All right. So another fair point would be to raise that there are situations where sometimes the tenant, sorry, not the tenant, the landlord might want to increase the rent unfairly. Maybe they'll just verbally say, okay, from next month onwards, I want 1,000 rupees more extra. Is that fair? Can that be done?
That is if there's no written agreement only.
Okay,
If there's a written agreement, you can't change arbitrarily, because the agreement provides. It can say, okay, first year this is the rent, second year so much of an enhancement of the rent. That can be provided for. But if there's no written agreement only, that the enhancement can be done just verbally.
Yes.
Otherwise, you can't violate the agreement. So if you then you have the option to vacate if you are not happy, and if you are not ready to pay that amount, then you can go. But at the same time, if those conditions are written, then that person can't, the landlord can't demand that money.
Okay. So earlier, if I go back to the same question once again about building and improving the house. So imagine a scenario like this. You own, maybe lawyer, you own a 2-story house where you have a rooftop, and somebody who comes to comes to see you requesting for a house on rent, you offer them the top floor so that they can build their own house. What happens then? When they want to leave? How do you? I mean, does the landlord will have to pay that person's expenses?
Firstly, you can't build like that.
You can't build like that?
You can't build like that without getting permission from the municipal council.
Right, okay.
Right, there are conditions, because you can't exceed certain number of square feet. You have to have certain other, like 2 stairways. There are certain other requirements. So you can't straight away say, no, you can put up a house. But you can, provided, right, then you enter into a proper agreement, you get approval, you get the building plan approved from the municipal council. If all those requirements are met, then you can, but then the terms will have to be specified in the agreement.
Right. Okay. So speaking about nuisance, sometimes the tenant becomes a nuisance to the landlord, which is very common. You can say that very often, almost everywhere it happens. It could be something about littering problems or something else, maybe the noise at the same time. What kind of relief does the landlord have in this?
Generally, in agreements, you specify you cannot be disturbing the neighborhood. If you are sort of if you are possessing the ground floor or the upper floor, you can say that you cannot be a nuisance to me, disturbance to me. If those things are there, then the agreement will provide that in the event, those are violations. Those fall into the category of a violation. If those are specified in the agreement, then you send them a letter, the tenant a letter saying you have violated this condition of the agreement, you have caused a nuisance to me by doing these acts, and then please vacate, and I am giving you notice. Here is the notice, now vacate.
Right. And what if the landlord, now I'm asking all the general questions because these are the questions that might actually raise to you might have as a general public. So another question would be about imagine you are the tenant, and then suddenly the landlord has already sold the land and the property. What happens then?
Nothing happens. My agreement has to be recognized by the new owner.
Everything goes back to the agreement. Everything is written in the agreement.
Even the new purchaser will have to recognize, because he is buying subject to my lease.
Right.
There's a lease in my favor.
Okay.
I am allowed to occupy these premises for a particular period. Sometimes maybe that I have paid all the monies due for the entire tenure. Then what is my position?
Exactly. Yeah. Right, that's a good point.
That is why a lease agreement, you must always get
clear.
a notarially executed agreement without getting these tenancy agreements, because the Prevention of Frauds Ordinance specifically says that you have to have an agreement notarially executed, that is before two witnesses. If that requirement is there, then you have complied with the law. So you are in a safe position to get your relief.
And it also acts like an umbrella on
Yes.
every situation. Right. There is also this situation now, this is something I have witnessed happening. Now, if someone stays in a land for more than 10 years, I don't know if this is something that this is like verbally known among everybody, that if you stay in one land or in a house for more than 10 years, you can claim the right to own it. Is that correct? On rent?
It is not correct for this reason.
Right.
You can't just wait there. Now I can allow you to occupy my house. You may be there, but you are there. Why? Because I have permitted you.
Oh, okay.
With my leave and license, you are living in that house. You are there, you can be there even for 100 years, but with my leave and license. Right? But if you, being there with my leave and license, if you start doing certain acts, you take the roof out and you put up new summer huts in the garden, or you start
Cultivating.
Cultivating, like if you have got, I mean, if you have been permitted to occupy the house as well as the garden, the land, there won't be any problem. Cultivating, there won't be any problem unless I have specifically told you don't cultivate.
Cultivate, okay.
Right? That is okay.
Right.
But if you start doing something against my right, against my wish, then you are doing something, some overt act. Those are called overt acts.
Overt acts, okay.
Right? Because against my title you are acting. Then I have to chase you out. I have to evict you. I can't take the law into my hands. All what I can do is I have to terminate the leave and license I have given to you. I must give you notice and say now vacate. If you don't vacate, then file action, and then I can even ask for other various orders, restraining orders, interim injunctions, preventing you from doing certain acts, taking the roof out, whatever the unlawful acts you are doing, and then get my relief.
Right. So just because you have stayed for 10 years in one place does not give you any right to claim like that.
Yes. Even if you have been, like, you can be occupying a house for 100 years, but you are paying rent to me.
Yeah. Okay.
Then that is, you are conceding my rights to the property.
Okay.
So even if you are there for 100 years, it doesn't mean a thing.
Okay. Right. There's also this other one, about 30 years, but also among siblings. If one sibling, if a land that is owned by 3 siblings is occupied by one sibling for more than 30 years, I've heard that it also works the same way. Is that right? I'm just asking you.
Well, co-ownership means my possession is, now we'll assume there's a particular land both of us own jointly. But you are occupying the land, but there's no dispute between us. Right? You always, we have been living in harmony. There's no problem. Your possession is considered as my possession as well.
Yes.
Unless there's an overt act.
Yeah.
Right?
Right.
But if you can prove that I have been chased out, I have not been given the produce from the land. I mean, there are 10 coconuts. I used to get coconuts from 5 trees. You have not given. All of a sudden, you have stopped. Then you are stopping me.
Right.
You are preventing me from enjoying. Then those, if you can prove that I have done this, then I may go to the police station and make a complaint. And then if I wait for 10 years, right, then those can be considered as overt acts, but those are not sufficient. There must be something grave
happening. Okay.
happening.
So it doesn't matter whether you're a sibling or just a friend or anything like that. It as long as the law is there, it governs everybody at the same time. Right. Okay, thank you so much, Ms. Nurain Amarasinghe, once again for coming in, because we have come to the end of the program, and today we discussed about the laws pertaining to to renting and lease agreements, and we'll be coming back in the next episode with another topic very, very soon. And thank you very much once again for joining in, and for you, have a good night.